The major question after we all finally got to see the footage of the famed QAnon Shaman being escorted around the Capitol building by multiple police officers on January 6th, even having doors unlocked for him along the way, is who exactly had seen this footage previously. January 6th Committee Chairman Benny Thompson implicitly denied having seen it himself, telling a reporter that this level of access to the footage is new. Even he wasn't able to see this video under the last speaker, though committee staff apparently did take a look, which raises even more serious questions about the supposed legitimacy of that process. Not that many are hanging on to delusions of legitimacy anyway, but it's not just a question of what sort of process we were all afforded in the propaganda show on our dime. It's a question of what sort of process Jacob Chansley, the QAnon shaman, received in court. Did his defense team have access to that footage, or was it withheld? Because if it was withheld, that's an outright constitutional violation in his prosecution. There is a third option, too, though. If Chansley's defense team didn't have this footage, was it because it was withheld, or was it because Chansley's lawyers were actually incompetent, maybe even somehow compromised, and didn't seriously seek it in the first place? As more information has become available throughout the week, it looks like some combination of all of the above. The Justice Department may not have been completely honest. Chansley's defense team didn't do a very good job either, and we're left with still more questions while this guy sits in prison for years for obstructing an official proceeding with the help of proceeding officials. On Wednesday night, Chansley's former lawyer, Albert Watkins, who represented Chansley when he pleaded guilty and was sentenced in fall 2021, said on Tucker's show that the first time he saw this video of Chansley getting a Capitol Police guided building tour was when Tucker aired it on Monday night.
Had you seen that clearly exculpatory tape of your client at trial?
No. The government knew. They knew that Jake had walked around with all of these police officers. They had that video footage. I didn't get it. It wasn't disclosed to me. It wasn't provided to me. I requested it. I filed the requisite pleadings for it. And whether I did or not, they had a duty, an absolute duty, with zero discretion to provide it to me so that I could share it with my client.
Court records do support Watkins' claim of multiple requests for any and all videos of Chansley in the government's possession, including surveillance videos. And requests did indicate a concern that potentially exonerating video evidence was being withheld. Watkins is also correct that the disclosure of that evidence, to the extent the government has it, which we now know that they did, that disclosure is not discretionary, as in the prosecution doesn't have the option to turn it over or not. It's mandatory. They must, not as a matter of procedural formality or some courtesy, but as a matter of constitutional law. Failure to do so is what's called a Brady violation, Brady being a reference to the case that established the rule. Brady versus Maryland, a Supreme Court decision in 1963. In this case, the court held that failure to disclose exculpatory evidence is a due process violation under the 14th Amendment. Where there is exculpatory evidence or evidence favorable to the defense, the prosecution has a duty to disclose. If they do not, that is a due process violation and grounds for a mistrial. So now you'll commonly see media sources questioning if the video Tucker showed is actually exculpatory. It's unclear how the footage could conceivably exonerate Chansley because, after all, it shows him doing exactly what he was charged with, walking around in a place he had no business doing so. This according to coverage in The Independent. But some journalists' assessment of just how mitigating the evidence is or not is legally irrelevant under the Brady rule. The judgment of whether the evidence is exonerating or not is for the judge and the jury on the case to evaluate, not the prosecution, and certainly not some uninvolved journalist with a predisposition against the defendant. If evidence favorable to the defense is withheld, that's illegal, even if it's only slightly favorable. All right, so let's all shake our fists at the DOJ and federal prosecutors then, right? They broke the law. That's why Chansley's in prison. So get him out of there yesterday because it's constitutionally required, right? Well, I do think there is plenty of that due, but the circumstances are actually much more complicated than just that. Because this isn't just a story of prosecutorial malice, or at least potential prosecutorial malice. It's a story of the defense's failure to do its job too. If this was a defense team supposedly so concerned with making sure all the evidence was seen, it makes no sense why they hurried into a plea agreement whereby Chansley agreed to plead guilty for no apparent benefit before all the evidence was even available. Since his guilty plea and sentencing, Chansley has changed legal teams. He's now represented by lawyers including William Shipley, who appeared on Tucker's show on Thursday night to answer Tucker's simple question. If Chansley's legal rights were violated, how is he still in prison? And Shipley immediately referred to the malpractice of Chansley's prior defense lawyer.
As a legal matter, how is this? Okay. How is your son still behind bars?
Well, Jake did not have a lot of post-conviction options. The plea agreement that Albert Watkins talked him into signing waived all of his appeal rights. He had limited rights to challenge the performance of Albert Watkins as his lawyer. When I came into the case, that's the first subject I began discussing with him, was my criticisms of what Watkins talked him into doing. Watkins had him plead guilty before the government was even willing to say it had produced all the video. The government in August of 2021 was still telling judges, we haven't been able to get all of the evidence to defense lawyers, so please don't set trial dates. Albert Watkins didn't care. He convinced his client to take the offer the government had made and plead guilty.
It's that timeline that's especially confusing. Chansley's lawyer wanted the government's video evidence, but then had Chansley plead guilty before the government even answered whether they had it? Apparently so. Watkins made those requests for all surveillance video relevant to the case in July 2021. On September 17th, according to a filing in this case, prosecutors said they were still developing a system to make those videos available to the defense. But on September 2nd, Watkins already had Chansley agreeing to plead guilty. In other words, while I'm not extremely inclined to take the government's word for it, and it's of course still certainly possible there were dishonest delay tactics or something similar going on, there is record of the government saying, we are working on getting you those videos you requested, and Chansley's lawyer saying, you know what? Who cares? Don't worry about it. We'll just plead guilty anyway. And plead guilty on extremely uncompromising terms, too. As Shipley, Chansley's new lawyer, wrote in an analysis at the time, a plea agreement is usually some sort of compromise position. The prosecution agrees to some sort of reduction in charges in exchange for cooperation from the defendant. Not this one, though. Chansley's plea agreement, arranged through his original defense lawyer, Watkins, gave the government effectively everything they wanted. A guilty plea on the most serious charge, obstructing an official proceeding, a felony, a charge that was commonly dropped for other defendants who actually fought it, given that all the other charges were misdemeanors with sentences that would have been served concurrently. There is no obvious benefit Chansley received in this deal. Had he fought the charges and been convicted at trial, or just pleaded guilty on all charges straight up, he would have faced the same fate, a felony conviction and a prison sentence in the neighborhood of 4 years. And it's not just that Watkins got Chansley to voluntarily agree to punishment that's on par with what he'd get with a guilty verdict at trial anyway. In some ways, it's actually much worse than that. As Shipley, the new lawyer, mentioned, this is an agreement that waives many of Chansley's rights to appeal, too. Now, obviously, if he's pleading guilty, he's not likely to appeal his conviction generally, but this is an agreement that goes well beyond just that. It waived Chansley's right to challenge the constitutionality of the law under which he was charged. Apparently a challenge that has been raised against the same law in other similar January 6th cases. Now, of course, just because Chansley's original defense lawyer appears to have represented him poorly, completely caving to the prosecution despite his current claims of fighting against them, that doesn't necessarily mean that the prosecution was honest either. Because even if we accept the prosecution's claim in September of 2021 that there was just so much video to process and they just needed a little more time to fulfill defense requests for records, it is amazing how quickly they collected the video when it was suitable for their purposes. Chansley pleaded guilty in early September when the government was still making such claims, but by November 2021, the government apparently got it all together because videos were feature evidence for Chansley's sentencing. Look at all this video of Chansley entering the Capitol building and the Senate chamber, yelling along with the crowd. That is not peaceful, the prosecutor said. making the case to the judge who would later deliver the 41-month sentence. If prosecutors presented video of Chansley entering the Capitol building and entering the Senate chamber, I have to believe they also saw the video of Capitol Police escorting him around and unlocking doors for him in the meantime. As far as I understand, even post-plea, the withholding of that evidence would still be a due process violation insofar as it's relevant to the sentencing and clearly relevant to the defendant's decision to plead guilty in the first place. And I'm no lawyer, but Chansley's plea agreement, as one-sided as it may be, does make an exception to the waiver of his right to challenge conviction or sentence if there is newly discovered evidence. As there now is, ineffective representation is also a potential grounds for challenge under this agreement, and based on the new evidence, it would appear he has a case there too. But there must be something more complicated that only the lawyerly eyes can see, because Chansley's new lawyer says getting him out still isn't that simple, though he does think the judge on the case may be receptive.
How do you get Jacob Chansley out of jail now?
Well, we're looking at that. I'm not sure there's an easy solution. There's not an easy road to that. In many ways, it's procedurally barred. We're going to have to come up with a creative way to get it back before Judge Lamberth. Frankly, I think Judge Lamberth may be a little bit unhappy that the government presented some videos at the sentencing to paint Jacob in the worst possible light, but I don't think Judge Lamberth today probably thinks he saw everything he needed to see when he made that decision.
And as a practical matter, the clock may run out before it means anything for Chansley anyway. He's been in prison since January 9th, 2021, over 2 years. That's credit on his 41-month sentence. And current DOJ records indicate he's eligible for an early release on July 9th, less than 4 months from now. It seems unlikely this matter will be legally resolved before then anyway. But of course, if indeed evidence was withheld, the question isn't only justice for Chansley to rectify the unjust prosecution, it's also justice for the prosecutors who did it to him. Though, obviously, don't get your hopes up for that. When they say Department of Justice, they mean justice against you. They don't mean justice against them, even when they're the crooks. Even when intentional Brady violations have been discovered, it's not like the prosecutors are getting locked up. They get referred to the DOJ's Office of Professional Responsibility for a friendly investigation by their own. Worst case scenario, these lawyers could face disbarment and therefore banishment from the profession, but as a practical matter, that doesn't happen. It's very rare and would likely only happen if some sort of egregious habit could be established. So don't misunderstand. They only ruin your life for minor infractions. They don't ruin their own, as this analysis on accountability for Brady violations notes. Their own malpractice is the only context in which the DOJ suddenly believes that deterrence doesn't work. Prosecutorial malfeasance doesn't need deterrence. What's far more important to deter is the threats to our democracy. That's the reasoning cited for the harsh treatment of every January 6th defendant, Chansley included. We have to ensure that nobody ever dares threaten our institutions and systems again, apparently oblivious to or dismissive of the fact that the betrayal of our commitment to the fair treatment of the accused is the much bigger erosion of our system and our entire concept of justice itself. You don't have to be a QAnon Shaman fan to recognize the real danger here, even if you hate him, even if you think he's a kook. If you have to pick one threat to deal with, would you rather deal with your political opponents unlawfully parading, perhaps even sticking around too long after they've been asked to leave in the form of trespass, or would you rather deal with the full force of the federal government's ire to put you in prison should they decide they don't like you, armed not only with effectively unlimited resources to do it, but a diminishing obligation to be fair to you in that fight? It's like a choice between fighting a rabid squirrel or cocaine bear. Sure, neither will be a pleasant experience, but one is a manageable problem. The other is a near-death sentence. At minimum, it's a life-altering experience for the worst. So empower the federal government to this degree at your own peril, because as soon as that cocaine bear is done eating your enemy, it's snorting another line, turning around, and coming for you next. Though perhaps that may not be so bad. Trial by cocaine bear will at least be a more efficient use of taxpayer resources, and it'll certainly be more ethical government treatment of animals than the way we handled those bats in Wuhan. So maybe in that way, Chansley's costuming was actually prophetic. It won't be long now until we're all in the business of spearing beasts for our survival. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on Minds. That is at ML Christiansen. You're always welcome to coming out and chat in my live streams. Those are linked down in the description. Looking forward to it. Goodbye.